My name's Andrew Clements. I'm the Chair of Employee Ownership Australia. I'd like to commence by acknowledging the traditional owners of the various lands on which we collectively meet today, and would really equally like to thank Jack for joining us this morning. Jack and I have worked together for a long time. Jack Hill is a partner in the King Wood Mallesons Melbourne office, and has worked in relation to employee equity issues for many, many years. In terms of the process for today, session runs, as we all do, for about an hour. We're aiming to have some questions at the end. Please, if you have questions during the course of today's session, please put them in the Q&A section. Equally, there's a chat section available. Perhaps by way of introduction, in terms of the subject matter today, I can say that at EOA we were very happy that eventually we did get some reform in relation to the corporate offering of employee ownership. It would be fair to say, like all children, we'd ask for more. There was the Oliver Twist moment in our lobbying. It is complicated. It's not perfect, but I think it is an advance on where it is. But more importantly, rather than me rambling, it's much better that we hear from an expert. So, Jack, please take us away. If you want to share your slides.
Thanks, Andrew. Let me try and do that. And I think when this happens, it's going to take over my whole screen. So I may not be able to see questions as they pop up, but Andrew will no doubt alert me to them if they do come through. Sorry, Andrew, you've got to enable me to share the screen, just like we practiced yesterday.
And that should now, yep, thanks, Jack.
Can people see that?
We can now, Jack. We just need to go on to slideshow and then start.
That better?
No, I think we'll need to go to slideshow at the top, and then
we're doing well. Let me. How about now?
It is. Yep, that's it, Jack. Fantastic. Perfect. Thank you.
Now that we've got the gremlins sorted, good morning, everyone. As Andrew said, my name's Jack, and I'm a partner in the corporate team at King Wood Mallesons, sitting in the Melbourne office. And today I'm going to take you through how the Corporations Act regulates employee share scheme offers. And before I go into the detail, there's just 4 key observations that I wanted to make up front, which will hopefully pique your interest in the information that I'm going to take you through this morning. The first, as you are no doubt all aware, and probably the reason that you joined this call this morning, there's a new regime that has just been introduced into the Corporations Act and actually became effective at the start of the month, which provides broad-based relief from the various requirements that might apply to employee share plan offers under the Act. And I'll cover that regime in quite a bit of detail this morning, but just to put it out there and to put it bluntly, as Andrew said, that regime is very, very helpful, particularly for companies in the unlisted space. The second point I want to make is, while that new regime is great and is helpful, it does have a couple of teething issues that ASIC is actually at the present moment consulting on to fix. And so if you are proposing to make an offer in the next little bit, it will be important that you carefully consider whether you rely on the relief provided by the new regime, or you attempt or continue to rely on the relief provided by the existing ASIC class orders, which remain in place until the end of the year, or perhaps some other exemptions that are available under the Corporations Act. The third point, just to flag up front, is that if you are intending to rely on the new regime, either now or once those couple of issues have been tidied up, you will need to review your offering documents and the processes that you undertake to prepare those documents, because there are some new specific content requirements that exist under the new regime, and the new regime also adopts or implements a new liability framework that attaches to those offering documents. So there is some food for thought there and some work that will likely need to be done. And the final point is that there are some conditions that apply to certain types of offers that are made under the new regime. And while those conditions leverage very heavily off the conditions that apply to the existing ASIC class orders, and they may look the same, the devil is in the detail, as is always the case, and there are some subtle differences. So you need to be very careful that you are actually complying with the conditions as set out in the regime, and not just thinking, well, we're continuing to do what we did under the ASIC class order, so everything's going to be honky-dory. So just to cover off very briefly what I'll touch on today, the first is just taking a bit of a step back and looking at what are some of the requirements under the Corps Act that might apply to employee share plan offers. And they are quite broad and varied, and I'll touch on those a little bit. I'll touch very briefly on the existing ASIC class orders, which most people will be very familiar with, and then we'll get stuck into the new regime. So we'll look at the scope of the relief it provides, how it differentiates between offers depending on whether participants are required to pay monetary consideration to participate or they're not. And then we'll look at some of the practical impacts of the new regimes for listed companies and unlisted companies and the practices that each of those will adopt. So looking back at the Corps Act as it was before the 1st of October this year, and just touching on some of the rules in there that might impact on an offer that you're trying to make. The most fundamental and familiar of those rules are the disclosure requirements. So as all of you are no doubt aware, the base position under the Corporations Act is that where you are making an offer of securities to an investor in Australia, the starting position is that you need a regulated disclosure document. There are obviously some very helpful exceptions in the Corporations Act that apply to disclosure, but those exceptions are for those disclosure requirements only. There are then various other rules within the Corporations Act that might apply to employee share plans offers, and those rules relate to on-sale restrictions, licensing requirements, including in connection with the provision of general advice in relation to the offer, or the provision of depository or custodial services. There's advertising rules, there's hawking rules, and most recently, there's been the introduction of design and distribution obligations that might also apply to employee equity offers where you're offering securities that are not ordinary shares. So there is a very, very wide range of obligations and requirements that you may need to satisfy under the Corporations Act in connection with an offer, and which of those will apply to an offer will very much depend on the terms of your offer and the circumstances of the company. Where the issue has arose is that notwithstanding there are some exemptions to the disclosure requirements built into the Corporations Act that might apply to employee share plan offers, and there are also some exemptions to some of those other requirements that might be relevant as well. There is no, or there was no one-stop shop that provided blanket relief or broad-based relief from all of them. And so what ASIC did many years ago, I think actually before my time, showing my age, is that they saw that gap and they saw, or they recognized the fact that enabling companies to make offers to employees is a very important tool for companies, particularly as we start to operate in a far more global market and we need to try and attract talent from overseas. And so what they did was introduced two class orders, 14-1000 for listed entities and 14-1001 for unlisted entities, which essentially said where you make an employee equity offer that complies with certain conditions set out in the class order will effectively give you blanket relief from any requirements that might apply to it. So all of those obligations and requirements that I just went through, the class order gives you relief from them. That class order or those class orders have been fantastic for listed entities because the conditions that you need to satisfy to be able to rely on the relief that the listed entity order provides are very, very easy to comply with and are generally administrative in nature. And the relief provides to basically any type of employee equity offer that you can think of. So as a listed entity, great, broad-based relief that's easy to rely on. As an unlisted entity, the class order was far, far, far less useful. And in fact, it was so restrictive in terms of the offers that you could make and get the benefit of the relief that in my experience, it was very, very, very rarely relied on by unlisted companies in practice. And the main restriction there was around the monetary value or the maximum monetary value that you could, offers could reach before the relief became unavailable. So basically, to put it bluntly, you were limited to making offers of $5,000 or less to employees. And in today's environment, that is a very, very, very small cap. And most people thought, well, if that's what I'm limited to, why would I bother with the time and expense of actually putting the plan in place? So, and as Andrew said, we were coming from a position where, although there was good existing relief for listed entities, the position for unlisted entities was far less helpful. And the regime itself was quite difficult to navigate because you obviously had the Corps Act where the requirement sat, and then the ASIC class order, which is where the relief sat. So filling that gap, and no doubt with thanks to the hard work from Andrew and others in continuing to campaign for this relief, the government came to the party earlier this year with the new regime, which, as I said, became effective on 1 October. And so what is really great about the new regime is it provides the same broad-based relief as the ASIC class orders did, but actually extends on it a tiny bit in that it now also covers those design and distribution obligations that I spoke of. So moving from the class orders to the new regime, we're not actually losing any of the relief that is available, which is great. The key distinction between or under the new regime depends on how offers are structured. And as I flagged at the outset, it differentiates offers rather than between offers made by listed and unlisted entities. It differentiates based on whether a participant is required to pay monetary consideration to participate in the offer. Where no monetary consideration needs to be provided, there are basically no conditions that you need to satisfy to be able to benefit from the relief. Effectively, all you need to do is, as part of your offering document, and this is an absolutely unregulated offering document because there are no specific content requirements that you need to satisfy when you're making an offer for no monetary consideration. You simply need to state that you're making the offer in reliance on the regime. That's not to say that you won't need some form of offering document, because of course, from a contractual perspective, you'll still need the participant to sign up and agree to the terms of the offer and the securities that they are receiving. And those terms will obviously need to be set out in a way that the participant and the company know what is being agreed to. So listed or unlisted, where you're making an offer that doesn't require monetary consideration, relief very, very easy to obtain, and that relief is very, very broad. Where you are or where your offer is structured such that it does require the payment of monetary consideration, and that could be the payment of monetary consideration at 1 or 2 points in time, either when the person accepts the offer and is applying for the security, or if they've been issued an option or a right at the time in the future where they need to pay to actually exercise that option or right. There are far more conditions that need to be satisfied to be able to benefit from the relief provided under the new regime. However, those conditions are, as I said at the outset, not dissimilar to the conditions that exist under the existing ASIC class orders. and I will touch on those in a bit more detail now. So the first condition relates to disclosure. And so you'll all be familiar with the disclosure requirements, or the requirements that an offering document needs to satisfy under the class orders. And we'll appreciate that they are prescriptive, but pretty administrative and easy to comply with. Effectively a set of warnings that you need to provide to the participant, and then some further information on the terms and where they can basically obtain other information to enable them to value the securities that are being offered to them, and assess the financial performance and viability of the entity making the offer. Those same conditions, particularly in the listed space, continue to apply under the new regime. And then in the unlisted space, there are again some slightly more burdensome requirements in terms of providing financial information and valuation information to participants. A couple of slight differences to the class order regime that I just wanted to call out. The first is that under the new regime, you need to give people 14 days to make a decision as to whether they want to participate in the offer or not. So under the class order, there was no application period or minimum application period, but one does exist under the new regime, and that is 14 days. So you need to take that into account when you're considering the timetable for your offers. The other point to flag, and this is again a key difference and may actually increases the burden associated with making offers that require monetary consideration by unlisted companies, and that is you need to re-provide the financial and valuation information 14 days before a right or option vests or becomes exercisable, if that vesting or exercise requires the payment of money at that time. So as an unlisted company, there may be 2 points in the cycle at which you need to give financial or valuation information to participants. So again, just something to keep in mind, because there is a bit of work involved in preparing that information. What does that financial and valuation information need to cover? There are very specific rules that are set out in the regime as to the scope or the form of that information. Helpfully, those rules are actually being expanded slightly through the consultation process that ASIC is undertaking to address a couple of those teething issues that I described earlier. The regime has been set up so that you can rely on the same valuation information that you would rely on for tax purposes. And it also allows you to leverage off valuation information that is being used in connection with a broader sale of the shares in an unlisted company. Helpfully, what ASIC is consulting on at the moment is also to allow for you to provide valuation information that is being prepared by an independent expert, which will effectively cover some gaps that exist in the new regime. The other point just to flag on disclosure, and again, this is quite a big shift to where we've come from, is that the regime introduces a new liability framework that applies to offering documents that need to be prepared. And that liability regime leverages very closely off the liability regime that exists for prospectuses under the Corporations Act. And the key thing to flag here is, as a result, it actually introduces deemed liability for directors of the offering company where there is a misleading statement in the offering document. That might sound quite scary, and it is to a degree, but in the listed company space, when you think about the information that is included in an offering document, the risk associated with it is generally pretty low, because all you're really doing is describing the terms and conditions of the offer and the securities. The risk position is slightly increased, at least from my perspective, for unlisted entities where you are needing to provide that additional financial and valuation information. So to put it in simple terms, there's a bit more risk that you might get something wrong in that financial or valuation information, which might lead to a claim from a person down the track. And so that deemed liability becomes slightly more problematic is not the right word, but an issue that directors of the offering entity are no doubt going to be interested in. Irrespective whether you're a listed or an unlisted company, as a result of the introduction of that new regime, it will be important that you consider the processes that you undertake to prepare your offering documents and the involvement of your board in the preparation of those documents, because similar to the prospectus liability regime, there are some defences to liability, including the standard due diligence defence, reasonable reliance defence, and the like. So it will be very, very important that companies consider the processes that they undertake to assist with the preparation of the offering docs, so that they can avail themselves and their directors of those defences should the need arise moving forward. The next condition that I just wanted to briefly touch on, and again, this is one that exists under the ASIC class order, is the cap on the number of securities that can be issued and still benefit from the relief. While there is a similar condition in the class order, the way in which, or the securities that count against that cap differ between the class order and the new regime. So this is an example of where you can't just continue to do what you previously did and think everything is going to be honky-dory. You're going to need to reassess the way in which you calculate shares for the purposes of the issue cap. The key difference here is that where you actually need to consider the issue cap, and so going back to the introductory comments, that's only where your offer requires a person to pay money. You need to consider all of the offers that you've made under an equity plan in the last 3 years. So previously you would only count against the cap offers that were made in reliance on the relief that was provided by ASIC. Now, when you need to assess the cap, you need to assess all ESS offers made in the last 3 years. And you're looking at offers, not just acceptances, which is another subtle distinction that you need to keep in mind. This is a point that we understand a couple of entities and advisors have tested with ASIC to check whether they might amend the issue cap so that it more closely aligns with the cap that exists under the class order. But ASIC has said that they are not willing to facilitate that at this stage because they think the drafting in the new regime that the government has introduced is deliberate. So we are where we are in this respect. I think one point that I would make, particularly from a listed company perspective, is notwithstanding the different way in which the issue caps are calculated under the new regime and the class order, it's unlikely to have much practical impact because most listed entities, at least if we were advising them, would make all of their ESS offers under the ASIC class order, and such that from a practical perspective, you're ending up comparing apples with apples anyway. Obviously slightly different in the unlisted context where it was now experienced slightly unusual to make offers under the regime and therefore needing to count them towards the issue cap. The other point that I just flagged very briefly, for those of you with operations or employees overseas, obviously where you're making those offers overseas, it's not the Corporations Act that applies to them, but the securities laws in the relevant jurisdiction. Under the ASIC class order, those offers to overseas participants didn't need to count towards the cap, but now they do. One final point on the issue cap is that it remains 5% for listed entities, it's 20% for unlisted entities, but there is flexibility to extend or expand the cap in the entity's constitution. And so I can't see a world where a listed entity would ever rely on this, because who's going to go to an AGM and ask your shareholders to increase the 5% cap? Not going to happen, but very, very helpful in the unlisted context where obviously you're dealing with a much smaller subset of shareholders, and there might actually be a strong commercial driver to expand the pool available to employees. So just something to keep in mind and in your back pocket if you ever think that the 20% cap might need to be expanded. There is flexibility to actually update that in your constitution. The next condition that I briefly wanted to touch on was the monetary cap. And so, as I explained, under the class order, the monetary cap was 5K for unlisted entities, unhelpful, which meant no one ever used the relief. It has been extended under the new regime, but perhaps not as high as some would have been hoping for. And so we're now looking at a cap of $30,000 as the base position. And there are some twizzles on that. Basically, it's $30,000 plus 70% of the sum of amounts of any distributions on ESS interest that a participant received in a 12-month period, plus any cash bonuses that the participant received that were subject to achievement of certain performance objectives. So not fixed rem, but bonuses. So you start with your 30 in any 12-month period, and then you can increase that by 70% of ESS distributions. Doesn't necessarily need to be distributions associated with the ESS securities that you're looking at, could be others, and then 70% of cash bonuses. There are then also quite complicated rules associated with rights and options, which allow people or companies to effectively roll up and aggregate amounts over I think it's a 4-year period. And so up to a maximum of 150K. So I'm not going to try and go through that on the call because it's hard enough when you're reading the legislation to understand what's going on without trying me to explain it now, and we probably don't have the time. But suffice to say, if you have a plan that involves rights and options and involves the payment of an exercise price, don't think that you're just stuck with the 30K cap plus those 2 additions that I spoke about. There is the ability to benefit from an increased cap if people haven't been paying exercise prices over the preceding couple of years. Couple of other very interesting and important aspects of the new regime. Similar to the class orders, they include specific provisions dealing with the use of trusts in respect of offers, the use of contribution plans, and the use of loans. So maybe just starting very quickly with trusts, still absolutely able to use those in connection with an offer. Nothing has changed there. And the requirements that you need to satisfy in connection with the use of a trust are very, very similar, or if not, I think just about identical to the requirements that exist under the class order. The one fundamental difference is that the new regime actually requires you to hardwire those requirements or restrictions into your trust deed, whereas that wasn't the case under the previous ASIC class order. And so what that means is companies will need to take a look at their trust deed and may need to make some, what I would say are quite minor and administrative amendments to them, but they're amendments that may be required nonetheless. None of those will actually change what happens or how the trust operates in practice, but to actually comply with the terms of the regime, there will need to be some updates to the trust deed. The other point just to flag is that there's always been a restriction on a trustee's ability to vote shares that sit within the trust. And effectively under the existing class order, the rule was that if a person hasn't told you how to exercise their votes, or if you held unallocated shares within the trust, you couldn't vote them at a general meeting. That position continues to apply, although there's another out which refers to voting in a manner which is consistent with the trustee's fiduciary duties. Again, in a listed context, I cannot see a world in which someone would actually seek to rely on that carve out, because I can't envisage a world where a listed company would want a resolution to pass just because their employee equity trustee voted in favour of it. It's just not a position that people would want to be in, but it has the potential perhaps to have a little bit more utility in the unlisted context. But again, it will very much be dependent on the circumstances. But just wanted to flag that because there's a subtle distinction between the new regime and the class order.
Jack, just a quick question for you, if I could. In relation to the trust deed, and the concept of having the restrictions hardwired in the trust deed, there are going to be instances where there are significant variations between particular offers and vesting schedules and restrictions. I wonder whether you had a view on how that, or does that mean that we're then going to need to include specific restrictions for each of the offers if those offers are different?
Yeah, so good question, Andrew. The conditions here are far more administrative in nature than fundamental terms of the relevant offers. And so when I talk about hardwiring into the trust deed, I'm talking about including statements that expressly says that the trust is being used for nothing more than employee equity offers, that it will keep, trustee will keep written records, that it won't vote, those more basic, generic obligations, as opposed to things that are offer specific and might change from offer to offer.
Well, and does that include restrictions on dealing with the securities, Jack?
No, it's to deal with fees, voting, records, and basically operations of the trust.
Thanks.
Contribution plans. One benefit of the new regime is they can now be used for other products other than just listed products, which is obviously great. The one negative is that under the ASIC class order, people used to have 45 days to action a withdrawal request. That grace period has now disappeared, which basically means as soon as you get a withdrawal request from a participant, you need to action it, and you can't continue to acquire securities after the withdrawal request, and any funds that are being held when the withdrawal request is made need to be repaid. And so practically speaking, this is going to have significant issues where companies rely on third-party service providers to facilitate and operate their contribution plans, because generally speaking, there is a period of time where the company needs to communicate a withdrawal to the service provider, or the service provider needs to actually action it. So that is going to, if you operate one of those plans, or you're planning to put in place one of those plans in the future, that is something that you need to be right on top of, because no longer do you have that grace period. The other point to flag is that the new regime will continue to require contribution plans to be opt-in plans. And by that, I mean people will actually need to sign a written application form or click a button on a website to confirm that they are comfortable with participating. Unlike some other offers, which have become far more common for them to be opt-out. The conditions in the class order require the contribution plans to be opt-in. From a loans perspective, I think much to Andrew's disappointment, these are still subject to the more detailed conditions and disclosure requirements. Consistent with the class order, they still must be non-recourse. But again, the types of securities that can be offered under a loan plan have been extended under the new regime. I think the only other interesting point just to flag here in an unlisted context is that if a participant is a shareholder in the unlisted entity, then they can't benefit from a loan in connection with an employee equity plan where you're seeking to rely on the class order relief. So again, just a little difference that you should keep in mind when you're thinking about how you might structure your offers or who might be invited to participate.
Jack, can I just make an observation in relation to that? That is a matter that we specifically made submissions in relation to, because the context of it was that the draftsman had in mind that a loan couldn't be made to a shareholder in an unlisted company because it would be a deemed dividend under the provision of Division 7A. So the view was that it wasn't adding anything. The aspect of it which is not correct is that the restriction which is included in the class order is much broader than what the equivalent prohibition would be under the deemed dividend provisions. Firstly, because the deemed dividend provisions include particular exclusions for employee share schemes, albeit narrow. And secondly, there are exclusions for particular sorts of loans, so that is or will be one of the areas that we'll continue to lobby in, because it's a limit looking for a reason.
Thanks, Andrew. The other point before we're getting to a couple of more technical issues is we've obviously spoken about the new regime applying to offers that don't require the payment of money to monetary consideration and offers that do. There's a third type of offer that can also benefit from the broad relief provided by the regime, and that's an offer that you make in reliance to one of the existing disclosure exemptions that sit in Section 708 of the Corporations Act. And so you might be familiar with exceptions, the small scale offering exception, the senior manager exception, or the sophisticated investor exception. Historically, people have been reluctant to rely just on those exceptions because you only got relief from the disclosure obligation, not the broader relief that the class order provides. But what the new regime does, which is absolutely fantastic, is says where you can fall within one of those disclosure exceptions, you get the broad-based relief, notwithstanding that hasn't traditionally been the case. So what that means is that you can actually pick and choose a little bit. So if you are making an offer that does require the payment of money, but you are only making it to senior managers, then it would be in your best interest to make that offer under the senior manager exception, because that would mean that you then didn't need to comply with all the other conditions that would normally need to be satisfied where you are making an offer that requires the payment of money. The one flag that I would call out is that where you are looking to make an offer under the small scale offering exception, so the 2012 exception, if your offer involves a trust, a contribution plan, or a loan, you still need to comply with the conditions that are set out in the new regime in respect of those aspects. That is not the case in connection with a senior manager or a sophisticated investor exception. The other point just to flag, and again, this is very, very helpful, is that where you make an offer in reliance on the new regime, it doesn't count towards your cap for the small scale offering exception. So again, you get maximum flexibility is the way that I would think about it when thinking about which avenue or which exemption and relief that you want to rely on. A couple of other aspects in relation to the new regime. The first is the types of people that you can actually make offers to relying on it. This has been broadened, which is very, very helpful. And it's been broadened in a couple of ways. The first is, as always, you can make offers to employees and directors, but it also allows you to make offers to contractors. Under the class order, there were specific rules around how much a contractor needed to work with the entity before they were caught. Under the new regime, those time of work requirements have disappeared. So any contractor of the entity, irrespective of how much or how little they work for the entity, can fall within the regime. The other really helpful thing is you don't actually need to be a current employee or contractor of the entity. You can be a prospective employee or contractor. So that is obviously very, very helpful in the unlisted space, where your ability to make offers to people or to explain the types of incentive arrangements that they are going to receive will be fundamental in them determining whether they're going to come to you or go to a competitor, particularly when you're fighting with overseas companies for that talent. Along similar lines, in the listed entity space, previously you could only rely on the regime once you had been listed for 3 months, although it had become quite customary to get relief from that condition. And now that condition has basically been removed. And so that is, again, consistent with the move away from differentiating between listed and unlisted entities. ASIC now, sorry, I should not say ASIC, the government has now said once you're listed, you can rely on the relief straight away. There is no longer any need to tell ASIC about your employee equity offers. So previously, there was an obligation to lodge a notice of reliance the first time you relied on the relief in connection with a specific scheme. It's fair to say that there was always a lot of confusion as to whether or what constituted a new scheme or a new offer. And so that resulted in some people maybe lodging a notice once at the very beginning and then forgetting all about it, or some people lodging a notice each year because they were ultra conservative. I'm thankful that I never have to answer that question again, because that obligation is gone. And it never really served any purpose anyway, because it's not like you needed to lodge the offer documents with that notice. It was just a simple one-pager. That's the other point to flag here, is that there is no need to lodge your offering documents with ASIC or any other regulator. That even the documents that need to be prepared as a precondition to being able to benefit from the relief. And then I think we've touched on the use of a trust and contribution plans and loan plans. Before I get to the things to consider, briefly touch on a couple of those myths that I spoke about within the regime that ASIC is consulting on to fix at the moment. The first relates to the on-sale relief that the regime provides. As you would be aware, the class order provides very broad on-sale relief for listed companies. And what I mean by on-sale relief in this context, there are basically rules in the Corporations Act that says where you issue securities to someone without providing them with disclosure because you've relied on an exemption, those people are effectively prohibited from going and selling those securities to someone else within 12 months of them being issued, unless there is disclosure made in connection with that sale. And so, as I said, class order provided relief from those restrictions. The new regime intended to, but basically it was a very restrictive form of relief, and said, yes, you can sell securities within 12 months of issue, but you can only sell them or transfer them to other ESS participants. So that is completely unhelpful in the listed company context, because I'm a participant, I get access to my shares, I want to go and sell them on the ASX because that's where the ready market is. This would not allow me to do that. So ASIC is fixing that. They know that that is clearly just a drafting boo-boo, and it's being rectified. ASIC,
and sorry, Jack, is that's in respect of both listed and unlisted companies?
No, unlisted companies will still be restricted to on-selling to people within a plan. But and so that is again a very deliberate decision by ASIC not to extend the same broad-based relief. The second.
Sorry, Jack. Sorry to keep interrupting you. In terms of would that then include not only the plan participant, but what might be the case where the sale is back to, say, an employee share trust?
Yeah, you would have to work out, Clem, whether the on-sale provisions actually applied in that circumstance, because generally you're only talking about when you're making an on-sale that would then subsequently need disclosure. So it's less of an issue in the unlisted space, because there's an open question as to whether you actually need to be worried about the on-sale restrictions in that context, is the way I think about it.
Do you think there's a realistic prospect, Jack, of getting qualitative or an appropriate outcome for unlisted entities? Because it does strike me that this is a fairly significant limitation.
But based on the commentary in the ASIC consultation paper, Clem, I would suggest there is absolutely no chance through ASIC whether the government would be more open. Query, but obviously that's not the position that was reflected in the regime, and I suspect that the fact that ASIC is now intervening suggests that perhaps the government this is not high on their list of priorities at the moment. Yeah. Salary sacrifice arrangements, the way that again, this is a little drafting nit that they didn't follow suit from the class order, and so there's a requirement for salary sacrifice arrangements for money that is sacrificed or deducted to be held within a trust account and an ADI, that there was an exception to that for salary sacrifice plans under the class order, and ASIC is flowing that through. Valuations we spoke a little bit about before in terms of broadening the scope of or the source of valuation information that can be provided, so that you can rely on valuations from independent experts. And then I think just to flag that ASIC has made very clear, although they're inviting people to provide them with other NITs that might exist, that they're not using, or they don't see their role as unnecessarily broadening the relief, just trying to fix errors in what was clearly intended.
Jack, just to make an observation, sorry to interrupt you again, but just to make an observation in relation to the salary sacrifice plan and the amendment or alteration to the rules for dealing with contribution plans. For what it's worth, during the consultative process, the thought process had been that an effective salary sacrifice for tax purposes did not have the provision of monetary consideration for the acquisition of the securities, so that those securities were provided free of payment, that being different to where I direct part of my salary to be applied to acquire something, so that the now conflation of that point now to include the salary sacrifice arrangement within the confines of the contribution plans is, I think, potentially an element of where the ASIC construction of what the monetary consideration proposition is or was narrows what was originally intended.
Thanks, Clem. That's very interesting. I'm conscious of time, so just a couple of closing remarks, and I think things to take away and consider. Most of these I've already touched on. The first is, particularly if you're a listed entity or offering a contribution plan, is it in the next, what are we, nearly the end of October, in the next 3 months before year end, is it better to do so relying on the existing class order relief, or do you want to rely on the new regime, obviously having regard to some of the issues that we've just discussed with the new regime? With my securities law hat on and having regard to everything that we've just discussed today, it seems pretty obvious to me that if I was designing a plan in the future, that I would design it in such a way that a person is not required to pay money, because it means from a securities law perspective, things are far, far simpler. But I appreciate that we are often the ugly stepsister to our tax colleagues. And so that will not necessarily be the sole determinant of the structure that you go with, but I think it does lend a lot more weight into plan design than perhaps it has historically. We've already discussed whether the regime will necessitate you to reconsider the way that you prepare your offering documents, particularly where they are required to be prepared under the regime and therefore subject to the new liability regime. I think it will have to. There will have to be some more oversight from the board, or at least some delegates of the board, given the deemed liability that now attaches to them. We've spoken about the need to perhaps change your trust deeds. I know that a lot of clients that we deal with have never hardwired those administrative aspects into the deeds themselves, and are in the process of updating them so that they can comply. And then finally, if you are structuring your offers, or you have historically made offers such that they don't require the payment of money, can you actually go about simplifying your offering documents? And so those same prescriptive requirements around warning statements and the like are no longer required. There's no longer a need to include what is often pretty generic and benign statements about the risk of participating. And so some little things like that, can you actually reduce the content of your offering documents and make them more user friendly? There's definitely some scope to go away and consider that space as well. that was about all I wanted to cover. So I might.
Jack, could I throw a couple of questions to you?
Sure.
One of the questions that's been raised, in a sense, is an extension of the proposition that I'd put before around perhaps what I would regard as a tax person as the proper construction of the no consideration exemption and salary sacrifice, and what that might mean to the primary obligation under the law of ASIC taking a different construction of it. So expressed another way, does the fact that ASIC is presuming that there is monetary consideration for an effective salary sacrifice plan mean that it's going to be difficult then to go back and rely on the no consideration or no monetary consideration exemption?
I think it is, Andrew. And I think the way that the regime has been crafted in and of itself makes it difficult to hang your hat on that approach. And the reason that I say that is where the regime talks about the conditions that need to be satisfied to benefit from the relief, it only talks about contribution plans in relation to offers that involve monetary consideration. And so trying to take the view that, well, a salary sacrifice doesn't, I think is tenuous given the way that the legislation has been drafted and the commentary that ASIC has put out as part of the consultation paper. I should flag that ASIC has intimated that it might consider putting out a regulatory guide in relation to the new regime in a similar way that it has a regulatory guide that supports the class orders. Perhaps there might be an avenue to pursue some more helpful statements from it as part of the formulation of that regulatory guide, if and when it ever eventuates.
Yeah. Jack, the other question, or building on a question for our audience, but more generally, is what does this mean for offers that are coming from overseas corporations? I know it's been the case for many years that we've had, well, sorry, in some cases that we've needed specific class order relief to deal with foreign offers. How does that operate, say, if I'm the UK parent making offers to security holders in Australia, in terms of the gateway of monetary consideration, firstly, and secondly, if there is monetary consideration, am I then going to need to craft my UK offer in a way that complies with the Australian offer, or am I going to actually need specific class order relief?
Yeah, you shouldn't, Clem. In my experience, the overseas companies that had trouble were your unlisted companies. And so the same rules apply irrespective of whether you're an unlisted company incorporated in Australia or an unlisted company incorporated overseas. There are some helpful tweaks that are being made so that if you're an unlisted company and you're making an offer that requires the payment of money, then the financial information that you need to provide can be based off accounting standards in the overseas jurisdiction that you're currently in. At the moment, the new regime doesn't facilitate that, but that's probably getting down a rabbit hole. I think at a general level, this new regime should make it far easier for foreign companies to make offers into Australia in much the same way as it makes it easier for unlisted Australian entities to make offers.
One of the questions, Jack, was just to provide, to give a little broader explanation of how a contribution plan operated in terms, I guess, in terms of its structure and what it is and how it's applied or how it operates.
Yeah, effectively, it's where someone you deduct wages or salary from someone for the purposes of acquiring ESS interests on their behalf under the plan. And so the rules in the new regime set out how you need to deal with the money that has been deducted in the period before you actually acquire the ESS interests, and then certain rules around how a person accepts such an offer and their ability to withdraw from the plan. and then what happens to deductions or future deductions or money that's already been deducted that hasn't been used. So that's it at a very, very high level. I think I talked about the key difference, the practical difference is with the new regime is the fact that you lose that 45-day grace period. And the rationale for the loss of that grace period seems to be that given contribution plans can now apply to a far broader audience, including unlisted companies, and people can actually put in place quite significant amounts, so up to 30K with the ability to extend, that it makes sense that people can withdraw and get their money back basically straight away.
Yep. One question, and I guess you alluded to it during the course of the conversation, Jack, was, and in a sense, what might come in the future. The essence of the policy proposition where there was no monetary consideration was, well, if you're not paying anything, you don't need to be colloquially protected from a securities law perspective. And the question then that had been raised is or was, if I had a loan scheme that had limited recourse, given that that's no risk, shouldn't that be treated in the same way? That was something that was put, but not adopted by government. I'm assuming, Jack, that there's little prospect of ASIC making that leap of faith.
I would safely say that there is basically zero prospect of that, Andrew. Yeah.
Because it does strike me that in the context of where we should be as an as a body pushing and promoting reform, that's a significant limitation, together with the secondary dealing element for unlisted securities.
Yeah. Great.
Jack, I think you've done beautifully and managed to fit an immense amount of detail into the allotted time. Can I thank you for your contributions today and your thoughts? It was, as with all things, when listening to an expert, there was a great simplicity about it. Thank you, firstly, and to the membership who are listening today, particularly in the context of concerns that you may have regarding the ASIC relief. We at EOA will be making a submission in relation to the ASIC consultation process. If you do have particular thoughts, please, to use that wonderful millennial expression, reach out to us. And more importantly, have a fantastic day.
Thanks all.
Thanks, everyone. See you soon.